Hi, I'm Adam Harris, and I'm going to tell you a little bit about Business Rescue in the few minutes we've got available. It's probably a concept that you've heard of because it's featured quite prominently in the news recently, but this is something that South Africa has recently adopted. It follows the international model, and it's something that has probably been long in the making as far as we're concerned. But let's try and deal with, in the time available, what Business Rescue actually involves. In the international concept, it's considered that an administrator is put in place to deal with, on a short-term basis, the administration of the affairs of the company and to ensure that a restructuring plan can be implemented. Now, that would work in different ways. What is important is that this now replaces what we had in the old Insolvency Act, which was judicial management, a concept that was introduced in the Act in as far back as 1936. I kid you not, that's as old as the Act is, but which has never really been used in South Africa. So Business Rescue is a variation, and what it essentially says is that the intention is to provide a temporary moratorium, in other words, that creditors can't enforce claims against the company, whilst an independent business rescue practitioner is appointed with a view to restructuring the company. Now, you must accept that it does not mean that the company will be restored to full economic health. Obviously, one hopes that this will be the case, or that either shareholders or creditors will receive 100 cents in the rand on their investments. But the idea is to maximize the return. And you do this whilst creating this temporary moratorium, as I mentioned, to allow the restructuring to continue. Essentially, the point of Business Rescue is that it's a process which should take place outside the courts. I mentioned judicial management a while ago, and one of the problems that one has is that court intervention was required. So in the case of Business Rescue, the Act provides that you as the debtor company can commence Business Rescue by a resolution of the board. That then has to be registered to take effect. But if you're in the position of a creditor whose debtor has now gone into Business Rescue, there are remedies available, and the courts will come to your assistance. At least that's what the legislation provides, if there are issues that need to be dealt with. For example, if one is unhappy about the particular business rescue practitioner who's been appointed, a court could be asked to remove that particular practitioner if there are procedural irregularities. And of course, it also runs in tandem with liquidation proceedings. The traditional model that we've had in this country over the last few years is really, it sounds a bit bizarre, but taking the patient, shooting it in the head, burying the body. That model is now being replaced. And the court, in fact, has a discretion to grant business rescue where a liquidation application is brought. And this gives another alternative to the traditional model that I've just described. So it's something that I think is going to take a while to take effect in the South African context. It is very new. The legislation was only brought into effect literally in April this year, and one would have to see how it pans out in practice. But it's going to revolutionize the landscape as far as this type of proceeding is concerned. And my suggestion is always, if there are aspects which you, either as a creditor or perhaps as a debtor, in other words, somebody whose company requires restructuring, would need to know more detailed information about it, then we'd be very happy to help you.